following program is classified G. It's suitable for all ages.
Tonight, we discuss the provisions to protect intellectual property within Sri Lanka. As the country moves towards a more export-centric economy, it has become paramount that the uniqueness of the local production is protected. The future seems to belong to those that lead production significant to the 21st century, a concept made clear when looking at the global leaders. The World Intellectual Property Organization, which oversees a system for countries to share recognition of patents, stated that China filed 68,720 applications last year, while the United States filed 59,230. The National Intellectual Property Office within Sri Lanka has reported that from 604 applications, 273 patents were registered in the year 2020 within this country. The process of application and registry of intellectual property has become pivotal if the creative manufacturing sectors within Sri Lanka is to move forward. Welcome to Law, Land and Liberty, where we discuss and break down pertinent legal issues for the understanding of laymen within this country. And today we have also selected something that has been within discussion and something that is actually contemporary to the course of this country's heading, and that is intellectual property and the laws related to it. We have a very important individual with us to discuss this. We have Dr. Nishantha Sampath Punchihewa, the Dean of the Law Faculty of Colombo. Thank you so much, sir, for spending time with us. Before we go into the topic, just to give a small breakdown to our viewers as to how we are going to take this forward, we are going to go into 4 key areas. Firstly, we are going to talk about copyright law and patents, then a bit about royalty for the content that is created by people, then on the laws on registrations for either patents or any form of intellectual property, and finally the offences related to intellectual property.
Hello, my name is Sydney Marigaspe and I'm currently pursuing my Masters in Business Analytics. My question is about copyright law and patents. What are the major copyright legislations present in Sri Lanka?
All right, let's go into the first segment directly. Once again, Doctor, thank you for spending time with us. This must be a busy time period for you now that you are the Dean as well. Our first segment, as we told you initially, is on copyrights and patents. Now, copyright laws and patents. Something you very clearly mentioned is this discussion needs some form of introduction, given that it's a wide scope. When it comes to intellectual property, it's a pretty intricate subject. How will you take some form of initiative in this regard, Doctor? How will you approach this subject?
Well, I think it is, as you mentioned, it's a pertinent topic that we all should know in this country. The topic of intellectual property has been one of the most important and widely discussed topic at the global level. I must say that a country cannot go forward or progress without protecting, respecting and commercializing intellectual property rights. For the very reason that the world in today's context is moving from innovation to ICT sector. So in this paradigm shift in the world order, one has to think of promoting intellectual creations and innovation. As Kumartunga Munidasa, one of the most respected poet in this country, academic, intellectual, once stated, the nation that does not progress in the world when there is no protection, when there is no respect to intellectual property protection. So this is one thing we have to mention at the very outset of this discussion. And as you ask this particular question, I would like to start with the concept of intellectual property rights. Intellectual property rights or concept of intellectual property protects the finest creations of human mind. I would say it is the intellectual creations of human mind.
Yeah.
And intellectual property, the concept of intellectual property protects a number of property rights emanating from intellectual creations.
The human mind.
Human mind.
Yeah.
And I would say it can be copyright, patents, industrial design, trademarks, trade secrets, geographical indication, so on and so forth.
Right. A very good sort of context that you gave to us, Doctor. If we move right in, I think you listed out the key areas where intellectual property rights are concerned. My first and primary question is going to be on, okay, what are the copyright legislations? Now, we have artists on one side, we have people introducing new inventions on the other side, and they all, as you mentioned, want to commercialize, want to make their products unique, and when they do so, if it is copied by someone else, they wouldn't know what their rights are. So if you could give a breakdown, Doctor, of what the copyright legislation is, because that is something more common when it comes to this thing. Yeah.
In Sri Lanka, the entire gamut of intellectual property is protected by the Intellectual Property Act number 36 of 2003 and regulations made under this act.
Okay.
And we also have case law development. So if I take the segment of copyright, copyright is protected by the Intellectual Property Act, and Intellectual Property Act is very clear on this, and section 6 from section 6 to section 6 to 27
right.
of the IP Act deals with copyright related rights and related matters. So very specifically, copyright, the concept of copyright is embraced or recognized in this Sri Lankan intellectual property law by section 6.
All right. That is where the law is significantly made present. I've also had the chance to go over this. Doctor, what are the key characteristics? What are the key features present within this?
In order to be protected your work, first and foremost, the most important matter in this copyright protection is the work. If I write a book, it is a work. If you create a song, it is a work. If someone creates a drama, it's a work. And for example, this program is a copyrighted work of TV channel, Derana. So it is, the work is protected, and work is protected by original creation, and it should be created by the author, and there should be certain degree of creativity gone into the work. For example, if I write a book, so my creativity is footprint. It is my seal will be in my book.
Exactly.
And this is original work of authorship is protected by copyright law of this country.
Exactly.
By virtue of section 6 of the IP Act.
All right. Professor, just feel free to go deeper into the section 6 and further parts, because now certain things that one would meet when referring the Intellectual Property Act would be things like publications are protected from copyright, and I think you really touched on this. Something I wanted to get more, and things like reproduction of your work, where those lines are met. I don't want to coincide two segments, because one segment we wanted to keep for registrations purely, but what can be copyrighted? What is considered to be material that can be copyrighted?
You raise a valid question here. That is subject matter of copyright protection. What can be protected? Books, speeches, dramatic and musical work, stage production, then audio-visual work such as films and etc. Then work of architecture, work of drawing, painting, photographs, then also computer programs, and many other subject matter with certain level of creativity from the author. Can be protected.
That measurement, Doctor, how does that happen? Should there be a registration process, or purely when you make it, you are protected?
In Sri Lanka, and also as per the Berne Convention, Sri Lanka is a state party to the Berne Convention. And as per the Berne Convention of 1880, 86. Copyright will be protected by mere fact of creation of the work. As soon as you created the work, the
work is copyright.
Work is copyright.
All right. A very important point. I want to make a segue into patents now, Doctor.
Yes.
I think this goes hand in hand, and we can really get your explanation right here so that it's clearer. Now, when it comes to our country, I believe we made a small analysis about 200 odd patents being applied for, and the registration process might even be smaller. So we need to expand that amount. We see other countries, the leading countries, maybe like the United States or China, having lots more patents like being applied for and registered on a daily basis. So how does patents work in Sri Lanka, Doctor? How can, like, if I have a creation, how can I patent this product?
That is a question that everybody in Sri Lanka should know, because in the aftermath of COVID-19 outbreak, many inventors, many researchers in this country have come up with their inventions. So a patent or patent is granted for an invention. Invention is a solution to a specific problem in the field of technology. Take, for example, the COVID-19 pandemic. And it is still being investigated. And if someone comes up with a solution to cure this particular disease, virus, so you are finding a solution to a specific problem, long felt problem in the field of technology. And that invention can be, of course, if that invention satisfies 3 requirements, the invention can be protected by grant of patent title. So simple answer to your question is, anyone invents new matter, new thing, if he or she satisfied the requirement set out in the IP Act, will be able to obtain a patent right. And copyright protects creations. Patent law protects inventions.
Okay. I think you made that distinction very clearly. So if one person is to expand now, I think you did make this explanation, but if you can really emphasize it on it more, Doctor, copyright and patents, the differences, how that differentiation is made, because one would say, okay, if this is not registered, maybe if this is not, if this hasn't gotten the patent, I am allowed to, reproduce it or use it the way I want to. Is that the case, or how does the distinction happen?
Copyright is granted for a creation. Creation is an original contribution in the field of arts, science, or any. It is
original creation.
It's an original creation emanating from the author. But patent, in contrast to copyright, a patent is granted for an invention. Invention is falling into the area of technological advances. If there is a technological advancement and there is a new finding, new invention, that can be patented, provided that particular invention, you would say research finding, I would say you put that idea into an invention, problem solution. You have a problem in the technology and you found a solution, and this solution is an invention. And if that invention is resulted in a new solution, then it should be able to be patented if that invention satisfied novelty. It must be new anywhere in the world. It must involve an inventive step. It should represent progress. It should represent a significant advancement in the technology. And such invention should be industrially applicable. It should be used in industrial purposes. if these three requirements are satisfied, that invention will be patented, registered in Sri Lanka as well as anywhere in the world. But copyright, when you compare patent rights with copyright system, copyright does not need registration. But in some countries, such as in the US, India and some other countries, copyright registration system is in place. That is the best evidence when you have your copyright certification, for example, for the software industry. It is the prima facie evidence that you can produce in any kind of legal dispute.
Okay, a lot of new and important information, Doctor, that you portrayed to us on our first segment itself. I have multiple questions that we wanted to take in association to this. We'll have to take a very short break. You are with Law, Land and Liberty. We are in conversation with Dr. Nishantha Sampath Punchihewa, who is the Dean of the Law Faculty in Colombo. Stay with us till we go into our next few segments and really take down and break down what intellectual property rights are within Sri Lanka.
Hello, my name is Katya Fernando and I am currently a biomedical science undergraduate. My question is about the royalty for content. How are artists motivated and incentivized under Sri Lanka's IP law?
Welcome back to Law, Land and Liberty. We are in conversation with Dr. Nishantha Sampath Punchihewa, the Dean of the Law Faculty of Colombo. Doctor, a very important segment that we just covered in terms of copyrights and patents, and you gave an introduction to the evolution of intellectual property within Sri Lanka. I think a lot of food for thought that we just got there. Next, now the commercialization aspect. Just so that we are clear with what and how this commercialization works. I want to approach this firstly by asking you, Doctor, you mentioned there were certain characteristics to get a patent. Where in the Act do you find this characteristic? Where can this be referred to if someone is looking at it?
Yes, I think our audience can see the Intellectual Property Act section. If I clearly state these sections, Part 4, Chapter 9 of the Intellectual Property Act, starting from Section 62, is the very idea of intellectual, the idea of invention. If I read from the text, for the purposes of this part, invention means an idea of an inventor which permits in practice the solution to a specific problem in the field of technology. Exactly what I mentioned. And Section 62 defines problem solution approach. And it goes on what can be patented in Sri Lanka. Products as well as processes. And subsection 3 of the Act is very clear what cannot be patented. For example, discoveries. Discoveries cannot be patented because it exists in the nature. But what can be patented will have to be understood in light of the provision here. And Section 63, the 3 requirements
that you mentioned before,
that I mentioned, these are referred to as conditions for patentability. Novelty, inventive step, and industrial applicability are provided in Section 64, 65 and 66.
Alright, okay. Again, another comprehensive understanding there. Now let's return to the commercialization aspect. Now, a lot of confusion here, Doctor, just clarify and iron out these details first. How can a person either make money through royalty or get some form of payment when something is either, let's not talk about penalties and offences as of now, but how can this commercialization aspect actually work when it's either patent or when you have some novel invention?
Yes. With regard to all intellectual property rights, be it a patent, trademark, copyright, industrial design, whatever it may be, the rights are, exclusive rights are granted to owners of these intellectual property rights. If I have a patent,
Yes.
I can either use it or I can give it to somebody else for commercialization.
Right.
I can, if I have a solution that can be turned into a product. Suppose a medicine to cure COVID-19
Yeah.
disease. So I can produce it and commercialize. I can put it into market. Same way, I'm not equipped with the necessary technology. I can license this particular invention which I have obtained a patent rights to you under a license. I let you produce.
Okay.
We call, in legal terminology, we refer this particular phenomenon as licensing.
Okay.
I can license it out. Or I can, if I want to get your technology, I will license in.
Okay.
So when I license my invention to you, you are on a contractual obligation to pay certain financial benefits. Give me, you have to pay certain financial benefit.
From what? From this product?
Deriving from the products.
Okay.
You have to give me monetary concession or how to,
Some form of compensation,
Some compensation, financial gains. Deriving from your work, you have to give me some portion.
Okay.
That is, in international treaties or in any other international document, we have seen this term royalty. Royalty is the layman's understanding. The word emanated from royal, it's a British word. But in simple terms, royalty means the licensing fee.
Okay.
And that is, you are giving certain financial benefit to me. Because I have permitted you to use my invention.
Okay.
So this is the concept of royalty. But in this IP Act, there is no mention about this royalty, the price royalty, but this particular act gives you a bundle of exclusive rights.
Okay.
When you have bundle of exclusive rights, you ask, any owner can give or license that particular piece of intellectual property. And for that, the owner will get, I'm the licensor and you are the licensee. And licensee will have to give the licensor the financial benefit, portion of financial benefit that you derive from this invention being used in the market. So that is the royalty. And royalty income is a stream of revenue from the part of the inventor. And there are different arrangements.
Yes.
But I would say it is mainly based on the contractual obligation. It is a contract between the inventor and the user or the other legal entity who is intending to use the invention.
Doctor, I think you very much approached my next question also there. Now, it will be based on the specific contract, it will differ how the benefit will go from either the licensee to the licensor. Very good understanding that was given to is what royalty actually means. I think a lot of our viewers will get that as something important to really bear in mind. If you can portray either through the act or either through between phrases how it's mentioned, it is the contract, or it will be different to specific contracts how someone will benefit, or should the patent or license be purchased in like one go and that payment is the only payment that is being given?
This is very important point because in Sri Lanka this contractual obligations are not being properly understood. Due to this reason, many inventors and also I would say the authors would have many issues coming all the way in their transaction, because the contractual obligation has to be negotiated and agreed upon. Then only you can enforce your licensing agreement. In the licensing agreement, the parties will have to agree, and royalty rates around the world will differ from industry to industry. In some industries, I have also looked at, for example, chemical industry, 4%, electronic 5%. Likewise, it is.
This is mentioned within the act or within discussions?
It's a percentage of the gross or net profit made on each sale of a product. So it depends, and it varies from industry to industry, and this has to be negotiated. And I think this is the culture that we should develop in Sri Lanka, and it is, I would say, it is still in its infancy.
Very important and very clear understanding given there, Doctor. Thank you so much for that. We have to go in for a short break, and we'll then talk about registrations and the peripheral sort of aspects to intellectual property. Before that, let's take a look at the weekly happenings within the legal field within this country. Here is a look at the law in the land.
Good evening, I'm Suzanne Shanali. Let's take a look at how the law has worked in our land. The Colombo High Court trial at bar ordered the central bank bond scam case to proceed in the absence of former central bank governor Arjuna Mahendra and Ajahan Punchihewa, who are currently hiding abroad. The case was taken up before the Colombo High Court trial at bar bench. The case involves the alleged misappropriation of Rs 36 billion worth of treasury bonds at the Central Bank of Sri Lanka bond auction of March 29th of 2016. The Attorney General sought further time to file objections against the revision application filed by former Akurasa Divisional Council or Pradeshia Sabha Chairman Sarwa Liyanage Sunil. Sarwa Liyanage was sentenced to 15 years rigorous imprisonment by Colombo High Court for allegedly raping an underage girl. A revision application had been filed seeking an order to release him on bail. Under the guidance of the Minister of Justice, a mid-time program has been implemented to improve infrastructure in a major popular way around the Alut Kadikot complex, Colombo, with the aim of running the judicial works efficiently and effectively. The project is being implemented aiming to increase the number as well as buildings with modern facilities for those courts and provide permanent building facilities to the Ministry of Justice currently installed within a rented building and several institutions under it. The committee appointed to review the demarcations of the jurisdiction and to increase the number of courthouses, including the High Court, presented its report to Justice Minister at the Ministry of Justice. The report of the committee, headed by Honourable Justice Mahinda Samyawardena, includes proposals for increasing the number of courts to 125 for establishing 74 new courts. Accordingly, 16 High Courts, 21 District Courts, 19 Magistrate Courts and 18 Combined Courts are proposed to be established. The committee also proposed to increase the number of Magistrates, District and High Court judges by 112. 3 persons, including the wife and father-in-law of former Minister Richard Badojin, have been arrested in connection with the death of a 16-year-old domestic aide at the former minister's house. Police spokesman SDIG Ajit Rohana said that 46-year-old Shehabdin Aisha, her father 70-year-old Mohammed Shehabdin, and the broker who brought the girl to be Badojin's house were arrested accordingly. The Barela Police, the Divisional Children and Women's Bureau and Colombo South Divisional Crimes Detecting Bureau are conducting investigations into the death of the girl. That was a look at the major events of how the law has worked in our land. I'm Suzanne Shanali. We will go into a short commercial break. Danilu will be back after the break.
Hi, my name is Rahul Karnara and I'm an engineering student. Today, my question is on the laws of registration. What are the key laws required for the registration of intellectual property?
Welcome back to Law, Land and Liberty. We are in conversation with the Dean of the Law Faculty of Colombo, Dr. Nishantha Sampath Punchihewa. Once again, sir, thank you for staying with us and giving us these clarifications. A lot of important content that you clarified within our first two segments itself. Now to a more technical aspect, the laws and the provisions for registrations for intellectual property. A point where a lot of people take a step back and mention, okay, bureaucracy, there's too much work to do, this registration is something that is difficult to get through. How will you approach this? I don't want to limit you with a question. I want to ask you, what exactly is the registration process? My following questions are going to be whether patent here is recognized worldwide, and I think you really touched on that in our first segment itself. But let's firstly start with how a registration process works. What is the organization? What sort of application should be made?
Yeah, everybody, every inventor, also creators, should know what is the process that you need to follow, because these are legal processes. When you have an invention, you must think of securing your rights. Otherwise, what happens? It will be used by anyone, anybody in the society, which would discourage you in investing your time, effort and energy in producing something viable, profitable to the society.
True.
The very reason of this intellectual property is to incentivize, promote innovation and creation in the world. Right? Therefore, registration is important because for the reason that you will get the prima facie evidence. You will get the certificate of registration. I would say in Sri Lanka, intellectual property rights are protected by there is an agency dedicated to the registration of intellectual property rights. That is National Intellectual Property Office, NIPO, National Intellectual Property Office.
Created through this act.
Yes, it was created through this Intellectual Property Act of Sri Lanka. Okay. And current act provides provisions for the registration of patents, trademarks, industrial designs. But we don't have registration for trade secrets, because trade secrets cannot be registered for the reason that if you disclose the secret, there won't be any protection thereafter. And geographical indications, for example, Ceylon tea, Ceylon cinnamon, can in other countries registered as geographical indication, but in Sri Lanka it is registered as a certification mark.
Okay.
But ideally it should be registered as a geographical indication.
Doctor, multiple things that I want to ask you. I will try and streamline it. When it's registered here, when a patent is registered here, is it recognized worldwide or is it just in Sri Lanka?
All IP rights are territorial rights. Okay. Territorial, I emphasize. Territorial rights because no country would respect patent right in Sri Lanka unless otherwise the inventor has secured, protected his rights in other jurisdictions. Okay. So, protection of intellectual property rights or patents in Sri Lanka at the National Intellectual Property Office would give assurance to you that your rights will be protected within the territory of Sri Lanka. If you want protection elsewhere, the best approach is to protect your rights in other countries by filing application in other countries. Because Sri Lanka has ratified in most of the international treaties, therefore Sri Lanka has modern IP system.
Right.
Certain things will have to be improved further. For example, the Madrid Treaty for trademark, worldwide trademark protection, and other Y.20 treaties we need to do in the future. But as of now, if you have coming very specifically to the question that you have raised, that is patents. If you obtain patent rights in Sri Lanka, it is valid within the territory of protection. That is Sri Lanka. If you want protection abroad, you need to file patent application. There are two routes. One is if you want to go to individual countries. For example, you want to go to India, you want to go to Singapore, you want to go to maybe Middle Eastern countries. Sure. Then you can, individual countries, you can, from the filing of the patent application in Sri Lanka, within 12 months you have to go and file based on the original date of application within 12 months. That is why your invention will be
considered valid,
protected from the date of the original filing, and you have to go within 12 months to the
original application, not when it is granted, but the application. Okay.
Because patent rights will be granted for 20 years from the date of application. Okay. So based on your first application in Sri Lanka, you need to go to other, I would say, legal term is jurisdictions or other countries. So you will obtain protection in other countries where you want to market your products, and this is based on, there's a simple theory called the prospect theory advanced by Sir Edmund Keith. And prospect theory, you need to analyze the market, and if you want to, any intellectual property right is a prospect, hopes, it giving hopes for you to make profits. So if you analyze the market segment, India is a big market. Likewise, European Union is a huge market consisted of 28 countries.
Okay.
Right? So if you want these many countries in the world to be to protect your inventions, invention, then the best way, file the application through Patent Cooperation Treaty.
Okay.
That is centrally administered by the World Intellectual Property Organization, we call WIPO. So if you want many countries to cover based on one application, I think it is more advisable to go through the Paris route, PCT route. But if you want to go to few individual countries, I think it is more advisable to go to by using the Paris route.
Okay, Doctor, since you did mention the WIPO, I want to ask you: is it binding? Is what if something registered or identified by the World Intellectual Property Organization? Will that be binding on all countries, or that also will be considered by countries worldwide?
The World Intellectual Property Organization is the United Nations specialized agency for intellectual property rights. And when someone obtains IP right or patent rights through this PCT route, then you have to go to one single application, but you need to get it validated in respective countries where you have applied for.
Okay.
That is that. And that will be protected. Then your invention or someone's invention will be protected in all the designated jurisdictions, but of course it involves a certain amount of money as well, because you have to go to individual countries and translate your application into local languages now.
Okay, that's a bit of a process there, as you mentioned. My next question, Doctor, copyrights. Now you did mention that within this country you don't have to register to get that the privilege of having copyrights when you have an invention done. You did mention that there are certain other countries where there is certain legislation mentioned. So is that an evolutionary aspect that we are looking at, or is it best to keep it this way and keep the legislation going this way? How can copyrights be protected better in the law?
Danindu, I would approach this respond to this question in this way. Registration per se is not a mandatory requirement. By mere act of creation of the work, the particular work is protected. That is the world recognized norm set out or provided in the Berne Convention 1880. Berne Convention 1886, right? And that is a norm. But some countries have introduced registration system for copyright. This is very important when emerging industries like software industry. Now Sri Lankan software industry is concentrating on ownership. In order to establish your ownership in highly intensive, technology intensive industries, I think it is best, it is an excellent move to create registration system.
Okay.
India has introduced, the US has introduced, and it is an optional requirement. But when you have registered and when you have obtained your certification of registration, it is the prima facie evidence to establish your rights. And in the US, you have also certain advantages attached to that registration.
That is an important characteristic. I think comparing how other jurisdictions does this is something that we need to really take into mind. Doctor, before we go into a break, I just have one more question. Now, you did mention that the sole authority that we look at when it comes to intellectual property is this act, and that really lays it down. But when it comes to registering things like company names, things like trademarks in that aspect, Sri Lanka has it diversified or divided those rights in specific acts, or is it different when it comes to registering a company name or and referring that to a trademark? Is there a distinction made there?
Excellent question, I would say. Business leaders in this country should pay attention on this matter, because there is a confusion among, I would say, small and medium-sized enterprises. Big companies, big players in the markets have registered their trademark with the National Intellectual Property Office. But small and medium-sized enterprises or businesses have not registered in most cases, because they understand business registration or company registration at the Registrar General, Registrar of Companies in Sri Lanka is suffice.
Okay.
Because it is not enough. I would say it is best if the trademark owner of the business and business leaders should register your business that is separate business registration.
Yeah.
But your intellectual property, your goodwill is attached to your trademark.
Exactly.
That is the most important aspect of branding.
Exactly. Very, very concise and very good context and comprehensive understanding given to us on registrations as well. Thank you so much, Doctor. We'll quickly go in for a short break and join our viewers on our last segment, where we talk a bit about the offences that are related to intellectual property. Stay with us on Law, Land and Liberty.
Hello, my name is Chamil Kavindra. I am a software quality assurance engineer. My question is about the offences related to intellectual property. What are the key offences recognized in the law in relation to intellectual property?
Welcome back to Law, Land and Liberty. We are in conversation with the Dean of the Law Faculty of the University of Colombo, Dr. Nishantha Sampath Punchihewa. Doctor, without taking any more time on this, I want to touch on the offences and really get that clarification also. Now, the next step to our after identification, after registration is, okay, what if someone violates your right? And what are the provisions that are available there? How do you approach this, Doctor?
Yes. Of all discussion, or of all matters that we discuss, I think this is more important for everybody.
True.
You must protect. It is not enough to protect. Protection is only one aspect. But we must also enforce. Unless you enforce your IP rights, nobody bothers about it. Therefore, in my standpoint, or in my point of view, it is the best, it is very necessary, I would say imperative, for a IP owner, copyright owners, patent owners to enforce their rights. I think there are, even maybe a few weeks back, even the Supreme Court handed down an important judgment. Likewise, now there is the tendency of getting your rights enforced. That is a good tendency. But still, the culture of respect for others' work is at the very embryonic status in Sri Lanka. Partly because we have sharing culture, but it is not the same in many other countries, and those developed countries in the world have protected their intellectual property rights, and most of the economies in the world are intellectual property driven economies.
Exactly.
South Korea, the US, Germany, and all these countries are very good examples. And Sri Lanka is also moving on the path of this Made in Sri Lanka drive, in which case intellectual property rights would be the most important aspect. And having said that, we should see whether and to what extent you can enforce your rights. What is an infringement? In the legal terminology, enforcement is dependent very much on the action taken by the exclusive right owner. Exclusive right owner can take action when there is an infringement. Infringement means the violation of IP rights. Violation of intellectual property rights happens where the outside or third party uses the work or the invention protected, IP protected work or the invention without the permission of the owner. The sooner someone else uses the intellectual property rights protected objects without the consent or the creation permission or the consent, that say the same act will constitute an offense, because intellectual property is protected and these are legal entitlement of the owner. And if it is taken away or somebody misuse, or I would say misappropriate the intellectual property rights, the very moment it can stand amount to a violation of intellectual property rights. In Sri Lanka, going to the provisions, Intellectual Property Act is very clear on this. If you look at section 170, coming under part 11, coming under part 11, procedure before courts, and you can see section 170, infringement and remedies in this section. So any infringement or threatened infringement can be remedied under this provision, and there can be injunctions and also award of damages for the act of infringement. And it goes on further, and if you see subsection 6 of the Intellectual Property Act, the court can also provide ex parte remedies, ex parte search warrants to inspect whether infringing products or infringing items are kept inside the particular place. So even the ex parte search warrants can be issued under this particular section. So in intellectual property matters, the action will have to be civil. If it is a civil nature, it has to be initiated in the Commercial High Court of the Western Province. Commercial High Court. So it is not the district court, but there is a specialized, specifically designated intellectual property court, that is in Commercial High Court of the Western Province. And with regard to, then it brings us to the next question. With regard to criminal sanctions, then we have we have offences and punishment under section 100 from 177 to 203. The provisions from section from 177 through 203 are the provision relating to offences and penalties. If you just look at with regard to the violation of copyright, section 178 is very clear. Any person who willfully infringes any of the rights protected under the part 2 of the IP Act shall be, very important, very strong wording, shall be guilty of an offence and shall be liable on conviction after trial before a magistrate to a fine not exceeding rupees 500,000 or imprisonment for a term not exceeding 6 months, or both such fine and imprisonment, and in case of a second or subsequent conviction, such fine or term of imprisonment, both such fine and imprisonment may be doubled.
All right. I think that's also a clear clarification of where the offences and the penalties are mentioned. Just a quick, we are almost out of time, Doctor. Something I just want to clarify is, within these penalties, you mentioned that it is the commercial high court that one should go to.
This is not, these are criminal sanctions.
Criminal sanctions, okay.
Punishments.
Yeah.
And this is dealt with the magistrate court.
Magistrate court,
So,
okay.
magistrate court of the area where infringement has happened or is happening.
Okay. Okay.
Are you clear?
Yeah, that is very
So, it is magistrate court. The offences under this section, from section 177 to 203, will be dealt by the relevant magistrate court. But civil action will have to be filed in the commercial high court.
Okay. I think that's a lot of clarification. Again, a lot of things that I have to ask you, Doctor, but we are out of time. I thank you for taking this time and joining us on Derana, Dr. Nishantha Sampath Punchihewa, the Dean of the Law Faculty of the University of Colombo, taking this time and really explaining something pertinent, something contemporary, and something very important to the Sri Lankan society. Thank you, sir, once again.
Thank you for having me. Thank you very much.
All right. Intellectual property rights have existed within Sri Lanka for quite some time, but hasn't been recognized by a majority of people, which has led to important discoveries and inventions taking time to be identified on the world stage. A key characteristic of successful global brands is the significant protection provided for their intellectual property. The value of intellectual property was something not identified in the recent past, but even during the 18th century. Thomas Jefferson, considered to be one of America's founding fathers and the draftsman of the Declaration of Independence in the United States, once shared this thought: "He who receives an idea from me receives instructions himself without lessening mine, as he who lights his taper at mine receives light without darkening me." It speaks to the inherent value that an idea carries without being sullied by the end user. Though Thomas Jefferson has come under a lot of criticism in the past few years as per his views on slavery, we must not lose value in his thoughts, bearing in mind the time period he lived in. That is all from us here at Law, Land and Liberty. Join us again next week as we bring to you another legal issue and provide a proper breakdown. I'm Daniduttanawasa. Have a great night.